Now I have the honor of introducing today's speaker. And I printed the wrong. I had this wonderful introduction. Now I see I printed the wrong thing. Okay. I know. So, Justice Reiber. I have a hard time saying Justice Reiber because he's Paul. Paul was born and raised in the Pittsburgh, Pennsylvania area. He went to Hampton-Sydney College in Virginia and then to Suffolk Law School. And then he and his wife decided to migrate to Vermont in the mid-70s, and he joined a law firm in Rutland. He was appointed to the Vermont Supreme Court by Governor Douglas as an Associate Justice in 2003, and then was elevated to Chief Justice in December of 2004. So he's been leading that crew for a while. He has taken on roles on the national scene with a lot of state justices and chief justice organizations, which would mean a lot if you're in the legal court world, but I'll let him tell you more about that. And then he very modestly at the very, very, very bottom of his resume puts HJD, Vermont Law School, and I wrote him and said, was that an honorary Juris Doctorate in 2013? And he said yes. So I'm delighted to introduce Chief Justice Paul Reiber.
Thank you, Kathy. Thank you. How's this working? Okay? Yeah? Good. I just want to make it clear, I'm not the magician. I've got no magic secrets to impart to you all, no silver bullets. I'm a lawyer by trade and have become something that I never thought I would have the opportunity to do, which is to serve this state as Chief Justice. It's been a terrific run. I don't want to sound like I'm retiring. As I mentioned before, take a guess at what you all would think is the mandatory retirement age for judges in this state. Just go ahead. Let me take a guess. Give me some numbers. What? Just shout it out. What do you? 90. 90. 90. And one of the things I always tell my friends in other states who almost literally drool over the fact that we're not forced out at 70 years old. We did have a mandatory retirement age. Hi, Betty. Even behind the mask, I see you. We did, our mandatory age was 70 for a very long time. It was in the Constitution. And then a great guy named Fred Allen was Chief Justice in the 90s. And the legislature, frankly, loved Fred, absolutely loved Fred. And they saw that he was approaching 70 years old, and they didn't want him to leave. I mean, this is the truth of the story. They didn't want him to leave. So they undertook to amend the Constitution, which in our state, as you well know, is not a simple undertaking. It takes two successive sessions of the legislature with votes in the towns and municipalities in between. It's a very difficult thing to do, but they did it in the 90s. Unfortunately, it didn't happen until after Fred had aged out. Something I'm sure they foresaw while they were debating it. But what I have wondered about is what the debate was on the floor of the House, because they took it out of the Constitution and they put it into law. It's a statute. It's a statute that they could amend, they could change now much more easily than amending the Constitution. And we could talk about that if you want. But what was the debate on the floor when they talked about what the age limit would be for judges? What was the other side of the argument? That's what I'm trying to figure out. You know, what is it that you will not do? Well, I won't go to life. That's what they would have said. I won't give judges life tenure. Of course, that's what federal judges have. Federal judges serve under the Constitution, under the U.S. Constitution, for life. It's life tenure. And the concept behind that, when the framers drafted the language in the Constitution, of course, was to insulate, or maybe I'll say try to insulate, judges, federal judges, from influence, political influence, by giving them life tenure. And that's what our federal bench has today. That's different than my judges. My judges are state court judges, Vermont state judges. We serve in every county of the state. The federal bench has two courts in this state, basically two courts, one in Rutland, one in Burlington. State courts are in every single county of the state. And in some counties, we actually have two courthouses. And as I have said to the legislature many, many times, when talking about our budget, your commitment to treating people fairly, to the rule of law, is marked in every single county of this state by the structures that you have built to the institution of justice that I serve, that we all have an interest in. So the courthouses in this county, which are right down the street, there's a county-owned courthouse across from the city library, and there is a newer courthouse down on Merchants Row, state courthouse. Both of those are markers, as I say, that I think demonstrates our state's commitment in every community of the state to fairness, to equal justice under the law. Now, having said that, are we perfect? We're not. I hate to tell you, but we're not. But that's not for lack of trying. And I can talk about that at greater length. But let me back up. I have here with me this afternoon copies of both the U.S. Constitution and the Vermont Constitution that I'm gladly willing to give away. Unfortunately, I only have about 7 or so, maybe 8 copies of the Vermont Constitution. I have probably 20, 25, something like that, copies of the U.S. Constitution. When we adjourn here, any of you who are interested in taking one of these copies, please come up and do so. I think perhaps one of the biggest problems we have in this country, and this won't be news to any of you, I'm sure, is the fact that we have a population in our individual communities, in the states as a whole, and the country as a whole. We have people who do not know civics. They don't, I think, understand the basics of what we have been founded on, principles of separation of powers, checks and balances. I actually And I'll tell this story with respect to all of you former members of the House of Representatives in Vermont and the state Senate. When I first arrived in Montpelier, which was a splash of cold water in the face in a lot of ways, it's a different environment up there, but a good environment. Don't get me wrong. One of the things I found out was that there were actually members, not many, but members of the House, new members of the House, this is back in '03, who thought that the courts were an agency within the executive branch. This is something that has stuck with me for all these years, and one of the things that compels me to come to events like this. I spend a fair amount of time in the legislature. As a matter of fact, I just finished a week ago today visits with open doors, so to speak, visits with at the legislature, sitting in the cafeteria for an hour on Friday mornings with invitation for people to come and chat, anybody to come and talk. It's been a great experience. It's something I've done for many years. I suspended it during COVID, but it's been terrific. And with the story about the courts as an agency in the executive branch, I don't mean to diminish anybody. I think it is entirely understandable that folks, I think probably a lot of people, might have that sort of misinformation. In fact, I think misinformation is a fundamental problem we've got in our society. And where you get your information, how you find sources of information that you know you can rely upon is challenging, to say the least. There are so many different opportunities to hear about things, to learn about things, that picking and choosing where you get your information is a challenge, and I wrestle with that myself almost on a daily basis. I've started reading, a variety of different news media just for that purpose. So let me go back to my arrival in Montpelier in October of 2003. I was not an appellate lawyer when I was practicing here in Rutland. I was a trial lawyer. I had argued maybe 2 or 3 cases in the Vermont Supreme Court. As a matter of fact, when I interviewed for the job with the Judicial Nominating Board, a process I'd love to talk to you about, because it's a very important process. It's the process how we seat judges in this state. And it's something I have great affection for. I served on that board myself, and it's a very important process. The governor in Vermont can't just appoint anybody he or she decides they think would be good. Governor can't do that. It's very different from the federal process for seating judges. Under the federal process, and the same in some states, the president or the governor in the state decides who they want to anoint. This is the person I want. And then there's an advice and consent process in the Senate under the federal Constitution and under our Constitution. But here the difference is in Vermont and in many other states is that the governor is not allowed to appoint just anybody. The governor can only appoint a judge who is submitted to the governor on a list of so-called qualified candidates. And that list is compiled by this board. And the board is 11 members. There are no judges on the board. By law, a majority of the 11-member board are lay people? Just digest that for a second. A majority are lay people. No judges. Lawyers are the other 5. The bar elects 3. That's how I wound up serving. And the House appoints 1 who is a lawyer and 2 more. And the Senate appoints 1 who is a lawyer and 2 more. And the governor has 2 appointments to that board. And the board is very, very thorough, very demanding, not in an offensive way, but very demanding of what they expect from applicants. The application itself is very, very long. It requires you to, as I have said to colleagues, to spill your guts. You've got to tell them everything. And then, in confidence, in a confidential session, they have an interview. And in the interview, the people who go first really are the members of the board who have been assigned your application ahead of time and who have delved into your references. They will look for information from people who are not listed as your references. You're required to provide names of adversaries in cases that you've had so that they are free and will call up the opposing lawyer and ask them what they think of you. And so this is the questioning that takes place in the interview session. And as you can imagine, it's a very important moment in a lawyer's life who is applying for one of these vacancies. And at the end, it takes a majority vote of the board. There's been some conflict in the legislature about whether or not that should be a greater number than a majority, but basically it takes more than not voting in favor. And then the governor, once the governor gets the list, has his or her own process that they follow, which includes interviewing references again, includes interviews as well. When did we adopt this? So this is something that I think is really interesting. We adopted this process in the mid-70s. Again, that was a constitutional amendment. Before the Constitution was amended in the mid-70s, Vermont appointed judges out of the legislature in a joint session of the legislature, and guess what? The majority of judges on the bench were former legislators themselves, and we wound up amending this process after Watergate. And interestingly, many states did the same thing, amended their processes after Watergate. And we adopted this system that I've described to you, which is called the Missouri Plan. Came out of Missouri originally. There are many states that elect judges. And I have good friends in other states who have been elected and gone through that process. And in fact, Pete Hall and I were at a session down in Manchester many years ago with a bunch of trial lawyers from across the country. And when we talked about this system of appointing judges in Vermont, one of the folks in the audience who was from Texas raised his hand and said, "So tell me, how many people of limited means does your state have on its judicial nominating board?" And his point, of course, was, in Texas, all the judges are elected. They're elected by popular vote, and the popular vote would necessarily include folks of limited means. But I don't think that's a fair criticism, because I think the system we have, as I've described it, is very, very much a system that I think the state can rely upon. So all of this is to say that the judges, all the judges in the state, except for probate, have been merit selected, is what I would call it. Probate judges are a slightly different animal because under the Constitution, probate judges are elected in the counties in which they serve. So they are elected. And under the rules, probate judges can practice law on the side as well. But we have an excellent probate bench, and I don't want you to take any notion that I would diminish any of the people who are serving on our probate courts. We have another type of judge as well in the state called side judge. This is a throwback to the 19th century, and the side judges by and large are lay people. They are also elected. So if you go into a courtroom in Vermont, a state courtroom in Vermont, one of our state courtrooms, you'll see 3 chairs at the bench. And the middle chair is the law-trained judge. The 2 chairs on the side are the so-called side judges, who are also county commissioners who manage the county budget. Many of our side judges actually are retired lawyers, and they do a terrific job too. By case decision in 1991 from my court, before I was on it, the Vermont Supreme Court said side judges cannot decide questions of law or mixed questions of law and fact. They can only participate in decisions regarding fact. So as a result, side judges primarily sit, with some exceptions, in uncontested divorces. So let me go back to the day I arrived at the court, because there's a short story I wanted to tell you. Any of you been to the Vermont Supreme Court? Maybe once or twice. The courthouse is a large, is it federal architecture? What is that architecture, Arthur? I don't know what it is, but it's a big granite building, flat roof. Like I said, I hadn't spent a lot of time there. And one of the first days I was there, one of the women who served as executive assistant to the judges was in the common area, and there was a door. This was on the 3rd floor, and I said, well, where does that door go? And we opened it. She said, I don't know. It was a circular staircase. So I said, let's go. We went up. It was to the roof of the Supreme Court. As I say, it's a flat roof. Our clerks actually make an effort to go there on the 4th of July because it's a great place to watch the fireworks. And we walked around the roof. There's some paving stones on the roof that direct you to walk in certain places and not walk in others. And as I turned around, the courthouse is here, and the 5th floor of the executive office building is here with glass windows. And I turned around and I see Jim Douglas and about 15 other people standing there going like this. I waved. I went downstairs. He called. He said, we thought you were going to jump. He had his morning meeting with his cabinet, and all those folks were there. And I had just come through his process and been appointed. He knew what a rude awakening it was to begin to serve in a capacity that I had no familiarity with. But it was a joke, and it was a good joke. One of the other things I wanted to tell you about was I have 3 brothers. None of them are lawyers. 2 of them are engineers. One of them is a social worker. And during the first days when I was working at the court, they all came from different places. They don't all live in, one of them lives in Vermont, the others live out of state. And we have a anteroom on the side of the courtroom where we put our robes on before we parade out onto the bench. And I knew my brothers were there with my father, who were all sitting in the last row of the courtroom against the back wall. And I said to John Dooley, who was serving with me at that time, I said, you know, my brothers and my father are out here in the courtroom this morning, and when we get on the bench, believe me, it would not be unheard of for them to start mugging from the back row and waving at me. So I said, I just want you to be ready for this. I'm not sure if that's up to the protocol that we ordinarily follow. And Dooley says, don't worry, if that happens, I'll point to them and say, I'll point to the defense attorney and say, and are those your clients in the back of the room? They behave themselves. So what I want to talk to you about is really not so much about me, but it's about the law. And I want to talk to you about what, in particular, our Vermont Constitution says. And I know when I talk to my kids and my grandchildren this way at the dinner table sometimes, their eyes begin to roll into the back of their heads. So I don't have a lot to say, but I think that some of these points, you know, I cannot talk about cases. We'll open it up for questions, and I'll be glad to talk to you about, you know, whatever your questions are, about the process that we follow at the Supreme Court, about what our management responsibilities are. If you look at the Vermont Constitution, the Supreme Court not only decides questions of law, which is what I'm sure all of you think about us, but we also sit as a board of directors over the management of all the state courts in the state. And as I said, we have courthouses in every county. We have about 400 employees. We have a budget of about $75 million. We have very little federal money that comes to the state courts. Frankly, nor do we really want it. And I can tell you about that. But the management responsibility that the justices have as a board of directors is a very weighty thing. And that's a lot of what I do, even though under the Constitution I have very limited power. But a long time ago, some years after Jim Douglas tried to wave me back into my office, I decided, you know, this job is what I am going to make out of it, not what somebody else tells me to do. And so it's been a very fulfilling experience from that point of view, and I can talk to you about that. But I do want to start with the law. You know, the Vermont, and I don't know if this is as motivating to any of you as it is to me. Don't forget, we were a freestanding republic from 1777 to 1791. Yeah, we were the 14th state of the Union. We came in 1791, but we were an independent political entity for all those years. There was a storied law professor from Washington that came up and spoke to our judges several years ago. And he said, you all have to remember, one of the most important things about your jurisprudence, if you don't mind me using a word like that, is the fact that you decided cases. You heard and decided cases. You developed case law from your Supreme Court from 1777 to 1791, not under the auspices of a federal constitution, but entirely as an independent political entity. And we still cite cases from that era. And, in a way, and I don't want to sound, independence means a lot of different things to a lot of different people, but we are an independent state. We are an independent jurisdiction. This state talked about secession from the Union in the 70s. It was a crazy time. It would be crazy to talk about it now. But that's the sort of Green Mountain Boys flavor that I think the state has always had. And by the way, we only came into the Union as a result of a negotiation that took place between our folks and the state of New York, because, the state of New York was arguing that these were New York grants. These were the king's grants through the state of New York, through the governor of New York, who I think was Clinton at the time. These were New York grants. Of course, New Hampshire claimed these were New Hampshire grants, but New Hampshire gave it up eventually, which, by the way, was as a result of us bargaining the center line of the Connecticut River to them. This still aggravates me. I tell my friends in New Hampshire about this. When I have GPS on in my car and I'm driving to Boston, I hit the bridge. Before I even get on the bridge to go over the river, it says, "Welcome to New Hampshire." It just aggravates me. But that's how it happened. And with New York, we paid, listen to this, we paid New York $60,000 to get their vote, to bring us in to the Union. And there was a great emeritus historian at the university who's gone now, named Sam Hand, who is part of a family of Hands. Sam was not a lawyer or a judge, but one of his cousins was a fellow named Learned Hand in New York, who was on the Second Circuit Court of Appeals, who was widely considered for the Supreme Court, for the U.S. Supreme Court off and on, but never was appointed. Learned Hand is the guy who gave a speech in Central Park, I think it was in 1951, called on the I Am an American Day. It was a day when they swore in immigrants, thousands of immigrants at this event in Central Park. And Learned Hand, I wish I had thought to bring a copy of the speech. It's very short. But Judge Hand spoke at that event, and he talked about what it means to be committed to the democracy. And the most important thought, I think, that he rendered was that living in a democracy doesn't mean that you've got all the answers. It doesn't mean that you know what the answer is to every problem. It means that you live in a mindset of curiosity, of wanting to understand better what the issues are, of inquiry, of dialogue. So this speech, which I commend to you, I really wish I'd brought it because you'd love to hear it. It's a great speech, and it's called the I Am an American speech by Judge Learned Hand. Anyway, his cousin, Sam, to get back to the story, Sam was an emeritus history professor at University of Vermont. He served, Sam Hand served on our professional conduct board. This is a board that serves as a source for complaints from the public about lawyers. You can complain to this board about your lawyer. You can complain that the lawyer has not behaved ethically, has not provided the service that they agreed to provide, that they've lied to you, that they've not reported to you frequently enough. That's what the board is for. This is constituted under the Supreme Court's jurisdiction under the Constitution, because under the Constitution, the Supreme Court is given, I won't say just authority, it's the responsibility, because it's a tremendous responsibility, to both license and discipline lawyers. And by the way, we also have responsibility to discipline judges. You can make complaints to an equivalent board called the Judicial Conduct Board about a judge who has misbehaved. And there are rules for both of these boards, not only as to how we populate them, and by the way, there are lay members on both boards, and this is how Professor Hand served. He was a lay member of the Professional Conduct Board. So anyway, Sam wrote a piece that was in, I'm sure it was in the Herald, it must have been, but I think it was, I remember it in the Free Press, on what's the anniversary of our state constitution, March 16? That's about right, isn't it? I should know this, but it's about that. And so he wrote a piece in the paper that said, you know, if we compound the interest on $60,000 that we paid those New Yorkers in 1791 to get their vote, it's a bunch of money. It's a huge amount of money. But he goes, but I think Vermont would be willing to waive that money if New York would declare March 16th of every year a holiday in respect for Vermont's Constitution. So I tell, there's a great guy named Jonathan Lippman, who was the chief judge of New York for a number of years, who's a good friend of mine. And I told Jonathan that story, and he laughed. He was not aware that they had paid, that we paid them $60,000. Let me go back to the Constitution. I get sidetracked. So here's one of the things that I would like those of you who take the Vermont Constitution. I speak to students a lot, and this is something that I bring to their attention, and it's a very important thing to guys like me, and I think should be to folks across the board. You look at the first article, and by the way, it's the same in 2 or 3 or 4 other articles of the Vermont Constitution. And remember, this is a document written in 1777. I mean, this is something that carries a tremendous amount of weight so far as it's never been amended. It's never been amended. The state of Vermont has had several constitutional conventions over these years, never amended this language. And what is the language I'm talking about? It's very simple. It says that all persons. It says all persons. It doesn't say all persons who live in Vermont. It doesn't say all persons who were born here. It doesn't say all persons who are male. It doesn't say all persons who own property. Many state constitutions do have that kind of provision in them. Not ours. Not ours. And, you know, I'm not here as an advocate, but except, let me make this clear. I have an ethical responsibility. Remember I told you about the Judicial Conduct Board? I took an oath I took an oath. I'm a constitutional officer, and that oath says I'm obligated to protect and defend the Constitution. That's the reason I'm here today. I have this responsibility, and I think there is a tremendous misunderstanding about what our values are, what the principles are that this country and this state was founded on. So it's just simple language. It's not complicated. There's no asterisk, there's no footnote that says, oh, well, maybe it's all persons, Reiber, but, it's not all persons, it's some persons. It doesn't say that. It doesn't say that. So I think this is a critical understanding that we have to come to. And by the way, this is not the only provision that I think bears remembering. Well, they all bear remembering, but Section 41 in the original Constitution, I looked this up this morning, is now Section 68 in Chapter 2, which is titled Laws to Encourage Virtue. Virtue. I'm not making this up. This is a quote from the Constitution. Laws to encourage virtue. What a word. What a word. This is what the people who wrote the Constitution said and what they expect us to apply.
Are you going to ask New York to take that off?
I'm going to send him a copy. When he learned that my mandatory was 90 and his mandatory was 70, he was beside himself. He was, believe me. It's another story of how Vermont won up New York. That's all I could say. So, laws to encourage virtue, here's what it says, shall be encouraged. What a concept. What a concept. I talked to the new members of the legislature last fall, and I talked to them about this. I said, please, read this. Just read it. It's not that long. It won't take you that long. This is the kind of language. There's another one. Listen to this one. This is Article 18 in Chapter 1. And by the way, this one is on the wall of the lobby in the Vermont State House. This is inscripted on the wall. Just hear this one. Article 18, that frequent recurrence to fundamental principles and a firm adherence to justice, to moderation, to industry are, I'm not making these words up, I want you to know that, are absolutely necessary to preserve the blessings of liberty. What could be more inspiring? This is what our Constitution says. This is who we are. We're not just some mamby-pambies from New York. Well, Steve, you were, but you've lived here a long time. Forgive me. I didn't mean to point that out. It's all right. I lived in New York a while myself. So I'm gonna stop there, but I think you can get the sense from what my remarks are that this is very important stuff and that we have forgotten about it, I think. I don't mean to disparage anybody in the legislature. As a matter of fact, on these Friday morning visits that I've had over the last month or two, a number of people came up who were new members and said how much they appreciated this language, hearing this language and hallmarking it. And let me say this too. Saying repeating these words is one thing, but actually implementing it, applying it, it's a very, very challenging. You know, we have, my group, the 5 of us, have a responsibility under the Constitution for access to justice. That's what the Constitution says. It says the court shall keep the doors open, basically. That's what it says. It's the court. It's us. We got to keep the doors open. And accomplishing that purpose is really no easy task. And I'll give you one example. Here's something I've talked about a lot over the several years, including more recently. Just imagine this. This is one of the things that gets me. If you are a young guy who is in the carpentry business, let's say, you've got a pickup truck, and you live up on the Canadian border, Enosburg Falls, you know where that is? Franklin County. It's way up. And you don't have a lot of money. And you got a job you got to keep, you have a family, and you get a traffic ticket, you get a speeding ticket, and you don't think it's right. But you know if you don't fight it, your insurance rates are going to go up. You might lose your license for 30 or 60 days. So you're going to fight it. But what do you have to do? If you want to fight the ticket, you've got to get in your truck and drive to the county seat for Franklin County, which is in St. Albans, which is 45 minutes or an hour away. And when you get there, you got to bide your time on our schedule, on my schedule, because I call everybody in who's got a traffic ticket that wants to fight it for the same time. We call them all in at 9 o'clock in the morning, and we hear them one after another. We've got a special judge that hears them one after another, and we don't give them specific times because a lot of them don't show up. They're defaulted, and we can't foresee that. We cannot foresee that, so we call them all in at the same time, 9 o'clock. Be there at 9 o'clock in the morning. This guy gives up basically a day's pay to try to fight a traffic ticket that he thinks is wrong for good reasons. And what do? We say, well, you got to do this you got to do this the way we say you got to do it. This has bothered me for a long time, and so delivering, let me go back to the fundamental point, delivering access to justice in the court system is not as simple for somebody who lives in a remote area of the state as it is if you lived down the street on Cottage Street in Rutland, Vermont, and you want to walk down to the McCaffrey Courthouse and argue your case. And how we fix that is a real puzzle. It's a real problem, because here's a solution I've suggested. I say, give us a bus. I'll get a commercial driver's license myself. I'll drive the bus on Saturday morning up to Enosburg Falls, park it on the curb, and we'll open the door for business. But we have a collective bargaining agreement with our employees. They don't work on Saturdays. We cannot perform this kind of service without lawyers and judges. And by the way, security, I'm sorry to say. Judges are threatened more and more every day. So you've got to have a deputy with you. So you've got to put, and how do you get the lawyers? You talk to Matt Valerio, the Defender General, he says, I can't get enough lawyers. I can't find enough lawyers. You want me to give you a lawyer for Saturday mornings in Enosburg Falls? I can't do that. So all I'm saying is, it's not simple. I'll give you one more example. And this one is a little closer to the heart. We had a case, again, in Franklin County. I don't mean to pick on them. Several years ago, we issued a decision per curiam. Now, per curiam means there is no specific justice who has authored the opinion. It's a rarity in our court. I probably could count on one hand the number of per curiam opinions we issued, but we did in this instance because we really wanted people to take notice of what the facts were. And the facts were, it involved a custody dispute with 3 or 4 kids. I can't remember exactly how many. One mother, 2 fathers. One of the fathers was in jail. The grandparents of the mother's parents have been granted conditional custody under the law. But after they had conditional custody, because people want to make trouble, if some people, when they can make trouble, want to make trouble, they found out that the grandmother had been substantiated by the Department of Children and Families 20 or 30 years ago. And so the lawyers filed motions. And the motions they filed were to disqualify the grandparents. And now we want experts to determine who it is that's appropriate to have custody for these 3 little kids. And the hearings that were required to take place were very involved and very lengthy. And the biggest problem was that the judge could not get the hearings to a point of conclusion. Because there were so many, everybody under our law, when a child custody is involved, gets a lawyer. So there were so many lawyers involved. Each of the fathers had a lawyer, the mother had a lawyer, the grandparents had a lawyer, the children had a lawyer. And every day that they tried to get the testimony resolved as to whether or not these grandparents were qualified to continue to have custody, that was the first issue. They'd run out of time, and the judge and the clerk would say, well, come back tomorrow. We'll finish it tomorrow. And everybody said, no, I got to be in this court. I got to be in that court. So here you had, and this went on for months. This is not something that happened and got resolved quickly. It went on for months. I think it was 6 or 9 months or 10 months before it actually came to a point of conclusion. And we issued an opinion, again, per curiam, in which we said, here is the system we have in Vermont. I'm not trying to point the blame at anybody. I'm not trying to blame the legislature for the laws that you've passed. I'm not trying to blame the lawyers who are representing the parties or the judge and the clerk. But this is the system we have, and who is suffering? Who is it that's suffering? It's the children. It's the children who are in limbo, who don't know, as one of my, back when, one of our guardians ad litem, I hope some of you are doing that or have considered it. It's a wonderful system. One of the guardians ad litem told me the problem his little guy had, at this time of year, by the way, was all of his buddies were talking about where they're going to go for summer camp. He didn't know where he was going to be. He didn't know in whose custody he was going to wind up. So he was after his GAL to say, can't you tell me where I'm going to be so I can sign up for summer this camp or that camp? No, I can't do that. I can't do that. This is a huge problem that we have in this state. And we're not alone, believe me. This is not unique to Vermont. So, on that happy note, let me stop and open it for questions. And if you want to talk about the Red Sox, I'd love to do that, but I can't talk about cases.